We will go on the record in the matter 25 CF 80, State of Wisconsin versus Shane Cook. This state appears through Assistant District Attorney Jose Vila in person. We have Nicholas White, Defense Counsel in person, along with Mr. Cook. We're set here today for a plea and sentencing. Mr. White, please update the court.
Your Honor, Mr. Cook was able to get an AODA. He completed that, and that satisfied the terms of this offer to amend count 1 to a misdemeanor possession of amphetamine. The agreement is to dismiss and read in counts 2 and 3 for a joint recommendation, cost and fine only.
Okay,
I have a plea questionnaire for you.
thank you. Thank you. And Mr. Cook, I do have to remind you that you are behind on your attorney's fees. Yes.
I didn't bring my hearing aid today.
Do you need a set, a hearing device?
Yeah, that way I can actually hear you.
Okay.
I forgot my hearing aid, so. I did talk to out here. She's gonna put a thing into my boss to make sure it keeps coming out, so I'll get caught up.
Excellent. Good. I'm glad to hear that. Thank you.
Put that by the microphone.
Thank you.
One more thing.
All right. Let me know. Can you hear me? Can you hear better, Mr. Cook?
Yes, ma'am.
Excellent. Okay, so you're going to take care of the attorney's fees. You're going to make sure that it's taken out of your check. That's great. Thank you. Okay, so I have heard the basis for the motion or basis for the agreement that's been reached. I need a motion to amend count 1 from methamphetamine to amphetamine.
So made.
Granted. Okay, Mr. Cook, I have in front of me the plea questionnaire waiver of rights form. Do you recognize that document?
Yes, ma'am.
Is that the document in front of you?
Yes, ma'am.
And did your attorney go over this document with you thoroughly,
Yes,
word for word?
yes,
Is that your signature?
yes,
You are pleading guilty to 1 count of possession of amphetamine. You're 45, you have 12 years of schooling, you can read, write, you understand the English language. Your attorney went over what the state would have to prove your guilt beyond a reasonable doubt and the maximum possible penalties, no mental illnesses or disorders, all correct?
correct.
You do take a medication. Are you okay?
Yeah.
That was loud, so I heard oh from the contact. Okay, so you do take a medication. Is it a medication that would interfere with your ability to comprehend or to understand things?
No, it's just for my asthma, plaque psoriasis, and acid reflux. That's it.
Okay, good. So nothing that'll interfere. That's great. Okay, so because you're charged with crimes, you're entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. You're nodding your head up and down that you know that. Did your attorney thoroughly go over those rights
Yes,
and you understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand here the state would have to prove on or around May 24th, 2025 in Burnett County, Wisconsin, you possessed a substance. The substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty upon conviction could be a fine of up to $5,000 or 1 year of incarceration or both.
Yes, ma'am.
Do you also understand that there is an agreement here for costs only? But do you understand I'm not bound to follow that recommendation?
Yes, ma'am.
I could sentence you all the way to that maximum possible penalty if I thought it was warranted. Do you understand?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Did you go over the criminal complaint with your attorney?
Yes, ma'am.
And in particular, that section called the probable cause section, where it says what happened and why you were charged with the crimes?
Yes, ma'am.
You're smiling and nodding your head up and down, so you understand.
Yes, ma'am.
Okay, and for the most part, are those facts accurate?
Yes.
Are you pleading guilty to possession of methamphetamine or amphetamine because you are guilty?
That's a tricky
Talk to
question.
your
Yeah,
attorney before you answer. Brief moment to discuss with counsel. All right, and so you had an opportunity to discuss what that means and the facts and all of the things with this plea with your attorney?
Yes, ma'am.
Okay, so are you pleading guilty to possession of amphetamine because you are guilty?
Yes, ma'am.
Okay. Mr. White, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes, you may, Your Honor. We stipulate.
Has anyone made any threats or any promises to you, Mr. Cook, for you to plead guilty?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes, ma'am.
Has he answered all of your questions?
Yes, ma'am.
Has he looked at this matter thoroughly?
Oh, yeah.
And you're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No, ma'am.
As to amended count 1, possession of amphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count 1. Count 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Before I ask for arguments, Mr. Cook, have you gotten your driver's license yet?
No, ma'am. I'm working on
Where are
that.
you in that process?
All I got to do is get enough time to go over and take my test. That's it.
Please do that,
Yes, ma'am.
because I don't want to see you in front of me for an OAR again, okay?
Okay.
All right. Okay, so Mr. Vila, argument?
Thank you, Your Honor. I would ask the court to adopt the joint recommendation. The crux of this case is that this was a personal use case. Mr. Cook didn't harm anyone. He wasn't dealing to the community. I think he realizes that he needed to get some kind of treatment. He did that on his own accord. As such, I would ask the court to continue to incentivize folks to seek out treatment so that they can continue on their path towards sobriety. As such, I would ask the court to adopt the joint recommendation for costs as being appropriate. Thank you.
Mr. White?
Thank you, Your Honor. I agree with the prosecutor's summary of this case. It appears to have started with a wellness check of Mr. Cook as he was in his vehicle and as he was exiting the vehicle. The item was found and tested. We've discussed some of the same things that's been brought up today, like his driver's license. That's something he's working on. I'm not sure if an AODA was necessary for that, but he has done one. So I think he's working towards that. We'd ask for this just to be a cost and fine only resolution because Mr. Cook, even though he didn't qualify for a public defender in this case, he does have some financial issues, and by resolving as a misdemeanor, he keeps his housing. He knows he has to work on his driver's license, and he's made that effort to appear in court. The AODA that he did from February 5th actually was done on February 2nd with Jessica Cowder, and I have a letter here from Sue Wheeler, the administrative specialist. From my understanding, Mr. Cook does have a follow-up meeting. It's just something he needs to follow through on. So that's all to his own benefit. I'd ask you to go along with our agreement.
Thank you. Mr. Cook?
Yep, the 28th, I haven't, she called me back and was asking, there's a couple of questions on there. She said it doesn't have nothing to do with this, but that she would like to talk to me about. So I said, okay, she needs to get back to me with the cost. And then I'll be set up on the 28th, I believe.
Excellent. Anything else you want me to know or you want me to consider?
Well, just thank you. That's all.
Thank you,
You've
Mr.
been really polite with.
Mr. Cook, I don't know you well, but I know you pretty okay-ish, pretty well, from the times you've been here in court. I want to say you are a nice guy. You do what you need to do. You've even walked from Webster to get to court.
I get
because
caught
you-
up like everybody else. Sorry, I mean, like anybody else, I get caught up with, somebody that I shouldn't have been with and end up getting what I got now. And I'm not, that's so far as I'm leaving it. That's, so I just got to make a better judge of who I keep around, I think.
I'm really glad to hear you say that because I do think you're smart and I think that you do put in the effort. I think, aren't you on disability or something?
No, I
Okay.
could have been, but I
That's
chose
what it
not to
was.
be. I can still work, so I don't see any reason why I could not just work instead of getting disability.
That's what it was. And I respect that a lot. I really, truly do. So you do want to work, you do want to be responsible, you do want to take care of things. You're following through with your treatment. You're going to be following through with getting your license. When you can't get to court, I'm going to be watching. And so you have actually walked a very long distance to come to
I
court.
even called the cops one time to make sure I got here.
And because and I like that because that shows me that you respect the court and you respect my authority.
Well, I do respect the law. I respect the law. I actually really do. It's just sometimes I mean, that's all I can say. Sometimes stuff happens and
I really hope you are going to be making better choices about your associates and their character and what they do, because all they're going to do, the
Yep.
negative ones are going to bring you down.
yep, even if I don't know what they do and I just need to be like the sheriff told me, you just need to be like, hey, what do you got on you? What is this? Where you going? If you don't, then just say, hey, I'll just walk. So and he's right. And like Dave had said the same thing, just walk away. Stop it before it starts.
I'm really glad to hear that because I don't take you for someone who would be using methamphetamine or those.
I was being stupid.
Don't do it again.
Oh, no, trust me, I won't.
Continue to take control of your life. I think that the agreement is appropriate. You're addressing what you need to address. You're going to continue to complete the things that you need to complete, even outside of this case. So I find that that goes a long way for the court. You're not a safety risk to the public. And you have a good character. So the court is going to follow the joint recommendation. I'm going to assess $443 in fines and fees. You do have $250 down, so you don't have to pay a lot, but that can be taken out in addition to your attorney's fees, and it can be in a reasonable amount that you can afford.
Okay,
So it can be taken out of your check. So I am ordering that you provide your DNA to the jail. If they need it, they'll take it. If they don't, they'll send you on your way. So when you're done here, you're going to go to the day reporting for jail and see if they need your DNA.
okay,
You have the right to have it request it be expunged through a written letter to the Department of Justice, not to this court, but to the Wisconsin Department of Justice. It's easy to do. You can Google it or you can ask Mr. White. He can assist you. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm going to leave the monthly fee to I think it's at $50 a month right now. So even combining the court costs, the remaining court costs and fees with any attorney's bills, we'll just keep it at $50 a month until paid off in full.
Okay.
If you fail to make a payment or you fail to pay it off, not only will the court enter a civil judgment against you because you're always going to owe it, but I will issue a warrant and you can sit up to 6 months in jail.
Oh,
Very
no.
important.
I will
Very
pay
important.
it.
I do believe that you will be making those payments. I think that covers everything, Mr. Vila.
I believe so, Your Honor.
Mr. White.
I think that was it.
All right. Good luck, Mr. Cook.
Thank you, Judge.
Good to see you. Hear or see, there's Mr. Olsiams. Mr. Olsiams, I am going to hit a button and for unmuting so you can unmute. Mr. Olsiams, can you see it? Is there a button to unmute? Okay. You don't have to have it unmuted now. I just wanted to make sure that you knew how to mute and unmute. Elizabeth Miller. I have somebody else coming in. Why do I have Elizabeth Miller wanting to come in?
She would be one of the
Okay,
plaintiffs. in this
thank you.
case.
I knew it sounded familiar. Okay. We will go on the record in the matter 23 CV 86 Rick Brimacone et al. Versus Carl Olsiums et al. We're here today in this matter on the motion hearing for Mr. Olsiums. He has filed, I believe, 4 documents that the court has in front of it. He was here in court on Friday, February 6th, for the contempt sanctions hearing. And then the court did make a finding that he intentionally and willfully failed to abide by the court's order for sanctions, and he did not meet the purge requirements. So he was brought into custody until he is able to at least meet the purge requirements. After being in custody, Mr. Olsiums did pay the total of $5,000 in the fines assessed against him for the violations. And after that, Mr. Olsiums did send a letter to the court that said, "Dear Judge Mogan, I am sorry, exclamation point. I have paid the fines and I won't rent my cabin again until I have the county permit, exclamation point, regardless of appeal. I promise, exclamation point. I was wrong about not getting the permit and I am truly sorry, exclamation point. I was selfish and not considerate of my neighbors. I ask for mercy and forgiveness," all underlined and capitalized. I have filings and a brief due for the appeal in a couple weeks. So I kindly and humbly ask you to release me today. Signed, a truly repentant and sorry Carl. That was on February 6th. On February 9th, the court did receive another letter from Mr. Olsiums in which he states, "Dear Judge Mogan, I have satisfied all purge conditions and am asking to be released as soon as possible. I came up with the following case law using the law library," and he cites 1, 2, 3, 4, 5, 6 different case laws as it relates to remedial sanctions and summary punitive sanctions. He ends by saying, "I am currently not underlined renting the property. Therefore, there is no continuing contempt. Thank you. And no finding of contempt is possible. Carl Olsiums." Then on February 11th, the court did receive 2, what the court would interpret as the actual motions. The other 2 were just letters to the court with information. On February 11th, the court did receive 2 letter motions from Mr. Olsiums. The first says, "Good morning, Judge Mogan. It's Wednesday, February 11th at 7:30 a.m. and I still haven't been released. So I'm wondering if there is a problem somewhere. On my end, I have satisfied the purge conditions. I have paid the forfeitures, and regarding the licenses, I am not renting the property. Susan, who is his now ex-wife, is the sole owner of the property now, so I couldn't get licenses to rent the property now, even if I wanted to. If there is a problem somewhere with my release, please let me know ASAP, as I need to be released. This is causing irreparable harm. Thank you, Carl Olsiums." After that, the court set a hearing for today. However, shortly after receiving that letter motion, the court did receive another motion, written motion from Mr. Olsiums, looking more like a legal document, and says, "Motion to immediately release Carl Olsiums from custody." In it, he says, introduction and argument, Carl Olsiams was placed in custody until he performed purge conditions of his detainment. The purge conditions are to pay forfeitures and to obtain rental licenses from to short-term rent that the property in Burnett County. Mr. Olsiams has paid the forfeitures. Mr. Olsiams is unable to obtain licenses because as of the date of this affidavit, he is no longer the property owner of the Burnett property and is no longer renting the property. Therefore, the purge condition to obtain licenses for the Burnett property, and he is unable to obtain the licenses. And then the second page, it has certain arguments in which he does place Wisconsin statute 785.04 paren 1 paren B, that imprisonment may extend only so long as the person is committing the contempt and that the contemptor has the keys to the jail cell. And when he does what the court order wants, or he is not able to perform what the court wants, the releasement must be immediate. Mr. Olsiams paid the required forfeitures on February 6, 2026. As the affidavit states of Mr. Olsiams, this payment is also in the case record. The affidavit of Mr. Olsiams also states that Mr. Olsiams is no longer renting the Burnett property and that he is no longer the owner of the Burnett property. Therefore, Mr. Olsiams doesn't need to and is not able to get the required licenses from Burnett County and the state DATCP rental license. And then he quotes, purge conditions must be feasible and within the contemptor's power to meet, end quote, citing the Larson case. Therefore, Mr. Olsiams has met his purge conditions and must immediately be released. He signed it, Carl Olsiams. He attached an affidavit, or what he believes is an affidavit, to the court in support. It has on top affidavit of Carl Olsiams with the legal caption. He states, I, Carl Olsiams, under oath on Wednesday, February 11th, 2026, state that I am not renting the Burnett property. I am no longer the owner of the Burnett property. I am not able to obtain a rental license in Burnett County, Wisconsin to short-term rent the Burnett property because I'm not the owner. I am not able to obtain a state DATCP rental license for the Burnett property because I'm not the owner. I paid the required forfeitures on February 6th, 2026 for case number 23 CV 0086. Signed this 11th day on February 2026 in Burnett County, Wisconsin. I do recognize that Mr. Olsiams believes that this is an affidavit. It is not a legal affidavit. It's nothing that the court can rely upon for multiple reasons. One, he states, I, Carl Olsiams, under oath, but there is no person that placed him under oath. This is not signed in front of a notary. Secondly, he says signed on the 11th day of February 2026 in Burnett County, Wisconsin. There is absolutely zero signature. There is no signature on this affidavit. It is not a legal affidavit. Moreover, if he was not going to have a notary, the civil laws and ability to not need a notary, that has changed within the last couple of years, and you can do affidavits without the necessity of having a notary, but you must state these exact words. It would be, I, Carl Olsiams, declare under penalty of false swearing under law of Wisconsin that the foregoing is true and correct. It must be dated, it must be signed, and it must have the location. Again, even if he had that required language and did not need to, in fact, have a notary, he failed to sign the affidavit. Therefore, it is not a legal affidavit that the court can rely upon. Therefore, the court needed to have this hearing because all I have is statements made by Mr. Olsiams, and at least to this point, his credibility is not held highly in this court. Can't necessarily believe what he tells me is to be true. And it's been shown time and time again, Mr. Olsiams wants to do what he wants to do, and he doesn't want to listen to the law. He doesn't want to listen to the court. He doesn't want to listen to the county. And if the court does not have authority over Mr. Olsiams, then I'm not sure what's left. Therefore, the court does have him in custody due to the remedial sanction that the court did find, I believe from, is it the August 2025 decision? And under remedial sanctions, I know Mr. Olsiams did want to try and learn the court or have the court learn the law, which the court is already aware of the law and does know how to analyze and read the law. Remedial sanctions, a court may impose one or more of the following remedial sanctions: payment of a sum of money sufficient to compensate a party for a loss or injury suffered by the party as a result of the contempt of court; imprisonment if the contempt of court is of a type included in Wisconsin statute 785.01 paren 1, paren B, or paren BM, or paren C, or paren D, and the imprisonment may extend, and I'm going to quote this right now, although I'm reading it verbatim, it may extend, quote, only so long as the person is committing the contempt of court, or 6 months, whichever is the shorter period, end quote. Also, another sanction is a forfeiture not to exceed $2,000 for each day the contempt of court continues, as well as D under the statute. Again, I quote, an order designed to ensure compliance with a prior order of the court, end quote. And E under that statute for sanctions, and I quote, a sanction other than the sanction specified in paragraphs paren A to paren D, if it expressly finds that those sanctions would be ineffectual to terminate a continuing contempt of court, end quote. So those are the remedial sanctions the court may impose, one or more of those following. And the court did do that. The court did order that he must pay the fines for each of the counts. The court ordered 45 days of jail per count to be ordered consecutively or to be served consecutively. The court also ordered that the jail could be purged upon full compliance of the court's October 4, 2024 order, as well as full payment of the fines and fees. That order was necessary as a sanction, not only to terminate the continuing contempt of court, but also it was an order designed to ensure compliance with a prior order of the court, as it has been shown and proven clearly to the court that Mr. Olsiam does what Mr. Olsiam wants, not what is the law requires or states, and not what the court orders him to do. So that order was necessary to ensure compliance with a prior order of the court. And under the remedial sanctions, the imprisonment, if the contempt of court is a type included in Wisconsin statute 785 paren 01, paren 1, paren B, it would mean it would have to be intentional, as it was here, and it would be fitting for Mr. Olsiam's disobedience, resistance, or obstruction of the authority, process, or order of the court, which again, here in this case, because the court did find that he engaged in intentional disobedience, resistance, or obstruction of the authority, process, and order of this court and this court's order. So that's why the remedial sanctions were ordered exactly the way they were ordered and why they were ordered that way. As it relates to whether or not the jail sentence can be concurrent or consecutive, the Wisconsin statute 785 says nothing about contempt sanctions, whether they can be served consecutively or concurrently. However, the legislature has given the authority to the court's inherent power in this area to impose sanctions as the court deems appropriate. And that is exactly what the court did. The court deemed the jail sentences 45 days each, which is very reasonable in light of the fact that the court could have done something more, and did have it be consecutive. This was not a punitive as in a summary sanction. This was a remedial sanction. And under remedial sanctions, the court may also provide a sanction to stop the past conduct so it does not continue in the future. In this case, the court does have Mr. Olsiums continuing to rent the property. He rents it for whatever period he rents it for, then he stops, then he rents it again, then he stops, then he rents it again, then he stops. So although Mr. Olsiums has argued, and I'll let him fill the court in as to his argument and what he wants the court to understand and to consider, he believes, at least how I'm understanding, that when you rent, then you stop because no one's renting, that stops the contempt, and then you rent, and then you stop, that stops the contempt. However, remedial sanctions are in place for situations exactly like this, which is ongoing conduct, which is conduct that continues for a particular time and stops, and where it's called, I believe, intermittent type of conduct or reoccurring contempt. And so that is exactly what happens in rental situations such as this. Therefore, even though there may be contempt for a rental period, it doesn't necessarily stop because no one is renting the next week. It is a continuing, reoccurring contempt. And there is certain case law as it relates to this. In one particular case, it emphasizes that remedial contempt, refusing to comply with the court's order, the sanction must be designed to terminate the continuing, reoccurring contempt. And that is exactly what the court did do in this case. And there are a couple cases that do follow suit with that. However, I did want to have this hearing so that I could allow Mr. Olsiums to be heard, because he does make statements, although he didn't make any statements at the time of the February 6, 2026 hearing, that he no longer owned the property, that he was divorced from Susan, and that she was awarded the property. He made zero statements that would even infer that that was the case. And in his first letter to the court apologizing, where he indicated that I won't rent my cabin again until I have the county permit, regardless of the appeal, I promise, leads the court again to believe that the property, the cabin, is still his property. As he states, it is his property. In the second letter, he says, I have satisfied all purge conditions and am asking to be released as soon as possible. But he did not at that time, because again, he made no statements that he no longer owned the property, that it was awarded to his wife during the divorce. So at that time, he still did not meet the purge conditions, because he still did not comply with the court's order, applying for both the state and the county short-term rental permits. It wasn't until February 11th, in which the court did receive those two handwritten motions with the non-authoritative or legal affidavit, which he does tell the court that he no longer is the owner, that Susan is the sole owner of the property. That is where the court then did have the need to set the hearing so that the court can understand if he in fact is an owner, if he isn't an owner, and why he didn't make any statement on the February 6, 2026 hearing, because that could have easily fixed all of this time that he has sat in jail, because there was nothing that the court had in its information or evidence or statements by any party that he no longer owned the property. And again, it wasn't until February 11th, 2026, in which the court had any inclination or any reason to believe he may not continue to own the property. So the court, upon receiving that motion on February 11th, set the first available hearing date and time that the court could set to let this matter be heard, to provide notice to the parties, as well as to fit it in the court's calendar. So Mr. Olsiums, I am now going to give you the floor for you to argue to the court what you want the court to know, and why you believe you've met the purge conditions. But first, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Olsiams, you may begin.
Well, again, Your Honor, we're here because I'm requesting immediate release because one of the purge conditions has been met and the other purge condition is not feasible and is not purgeable because I don't own the property. Again, you made a comment on the February 6th hearing that I didn't mention that I don't own the property. I kind of felt like I didn't get an opportunity to mention that.
Oh,
It felt
Mr. Olsiams, so you know, I have read all of the, it's called real time, where my court reporter takes down every single word that's said. It's not a legal transcript, but it's real time, so I can see what's being said
Okay.
in case I missed something. I have reviewed every single statement that was made in that hearing. You had plenty of times because you kept saying my cabin, my cabin, my cabin, my cabin, multiple times. So at any time during that hearing, you could have said, I don't own that cabin anymore. But you didn't. And again, I've read it and it's like 95 pages long. So not
Okay.
one time did you say that. So I would think very clearly about what you're saying to the court. That's
Mhm.
easily checkable because you are
Yep.
under oath.
Yep. Okay, so again, the forfeitures have been paid. Now regarding the licenses, the divorce decree was final on November 7th of 2025.
And the
Suzanne was,
court, I'm going to let you know the court, go ahead. Sorry.
okay. So again, the official final divorce decree was final on November 7th of 2025. So we're waiting for the final decree to come out about whether or not to apply for these permits. The divorce decree comes out on November 7th, and Suzanne is awarded sole ownership of the cabin in the decree. And that's again on November 7th, 2025. Suzanne then recorded a new deed with Burnett County in December. And if you look online, you will see that she is the sole owner.
Well, I can't
Yeah.
just look online. I
And I have-
actually will need to get actual documents of that.
Well, I actually have the document on my
With you?
phone. Yes, I do.
I can't take your phone. And I don't
No,
have
I
your
know that-
phone.
No, I know that, but I have the document on my phone. I just
Okay,
need
I have the
access to-
ability to, just so you know, I have the ability to be able to get a copy, but I don't now. I need to hear because quite honestly, when I reviewed and read your motions, I didn't believe you.
Okay, well, I'm sorry you feel that way, but again, this is all verifiable fact. I'd be pretty big stretch to say that this divorce decree didn't happen and that she wasn't awarded the sole custody, sole ownership.
And for the record, Mr. Olsiams, I do believe you now because based upon your motion, I am taking judicial notice of County of Washburn, State of Minnesota, Family Court Division, court file number 82-FA-24-3716, in which I do have a full stamped copy of your divorce. I was able to get that online with criminal
Okay.
or with court records. So I was able to get that. So I could read, and I'm going to let you know, I did read and she was awarded that, but I don't have, I need the proof that it is no longer in your name and that you are no longer going to be associated with it in any way, shape or form.
And I have that. It's on my phone. Her attorney, I actually subscribe to a service that when somebody makes an entry on your property, I got an email. And I saw that her attorney had filed the divorce decree and stating that I was the grantor and she now has sole possession of the property. And I have a copy of that on my phone because her lawyer sent that to me. So I just need to get the document off of my phone to give you a copy of the actual recorded document that he did with Burnett County.
Mr. Olsiums, and also, do you understand what I said about your so-called affidavit and what's wrong with it and why I couldn't even
Yes, I do,
rely
but-
on it?
Yeah, yes, but I'm sitting here and I have no access to any resources here. I had to plead for a pen. There's no resources in here to do that. So I just kind of at my best recollection.
And that's
did
fine.
what I-
That's fine. And I get that. But the number one thing is you didn't even sign it.
I thought I did sign it though.
Nope,
I think,
you did not. I have it right here because my job is to go over things with a fine tooth comb. And I know you can't see it, but you didn't even sign it. It
Well, to be
says right
honest,
at
Your
the
Honor,
bottom. Signed
was
this
told-
11th day of February 2026 in Burnett County, Wisconsin. Zero signature, big circle question mark, because zero signature. There's no signature on it. So even
well,
if I
apologize.
put the under oath thing aside, I don't have a signature.
Well, I apologize for that. Again, I limited resources here and I just, based on my best recollection that I could, I put together that affidavit to give the court some kind of an official reading in the record that I'm no longer the owner of the property.
I get it. Limited resources doesn't mean you lost the pen as soon as you wrote the sign this 11th day of February and you couldn't sign it. That's not limited resources.
Okay, well, I apologize. I can create another affidavit. If the
I
court
don't
wants
need
to.
it now. You're under oath. I'm getting the information that I need. I put you under oath. And so I'm gathering the information that I need. And again, I took judicial notice of your Minnesota divorce case, the findings of fact, conclusions of law, order for judgment and decree. And so I've read it. I've read all, it's very long. It's one of the most lengthy findings of fact I have ever read in my life. It is, they don't label the page numbers, unfortunately.
Would you
It's
like
very,
me to-
very lengthy.
Would you like me to get you a copy of that official recording that was done at
No,
Burnett County?
you can't, you don't have your phone. And you won't be able to print it and give me a copy. I have ways I can do in order to get it, or I can get a copy of it. I'm not worried about that. I just want to know now that you're stating that it was awarded to your wife. I confirmed that. And that you're telling the court that it was legally transferred to her name only.
That's correct, and that happened in December.
Okay, so I can look at that.
Yes.
All right, what else would you like me to know?
So then again, just technically, the forfeiture purge has been satisfied. The license purge condition is not feasible because I don't own the cabin. And again, on the Larson case, the Supreme Court said that the purge conditions must be feasible and within the contenders' power to meet. Obviously, if I don't own the property, I can't get a license. So that purge condition then is really irrelevant or moot, or because Suzanne now controls the property, not me.
Yes, and I need to get proof of that, and that's where we are. And I appreciate the fact that you went to the law library in the jail and that you found a book or something, and you wrote down all the case law and all the brief summaries of the cases. I know the law, Mr. Olsiums. I truly know the law. When I got your first letter, you didn't meet the purge conditions. When you got the second letter, you didn't meet the purge conditions. It wasn't until the third letter that I had any inkling that you may be unable to meet the purge conditions. Okay. And then with the additional motion, that's with the affidavit. If it was a signed affidavit, it would be stronger in the court of law, but it wasn't. But again, the 11th was the first inclination that I had that you may not be able to meet the purge conditions. And so that's why I needed to have a hearing so I could hear it from you. It wasn't signed under oath, or it wasn't signed declaring penalty of perjury or sanctions of the court. It wasn't signed at all. So anything else you want me to know?
Well, just that I'd like to be released immediately. I have a number of matters and affairs that it's causing irreparable harm. And I need to be released immediately.
I appreciate that, but your continuing contempt, your reoccurring contempt, your ongoing contempt your intermittent contempt, all of that causes irreparable harm to the plaintiffs in this case, as well as to the county and the state, because you're not doing what you were ordered to do. So I get
Right,
your argument of irreparable harm.
Right, so I don't own the property anymore, so I can't meet that purge condition, so.
Okay,
That's why I should be released.
all right. Mr. Anderson, I'm guessing you're here just because you're a part of the case. I don't know if you have anything you want to argue to the court.
Your Honor, I don't have anything I want to argue. We are not taking a position, but I would have one question for Mr. Alciums, if that's okay.
I'm fine with it. Go ahead.
Mr. Alciums, is your divorce decree, are you appealing that decision from the court in Washington County, Minnesota?
Oh, I can give you that information too. He's already appealed. It's been denied because he was late. It's been denied twice by the Court of Appeals. I have that attached to this findings of fact as well.
Okay.
Those
Thank you.
are, I should have went over that too. Sorry, Mr. Anderson, I don't mean to rain on your parade.
No, that's okay. Just information.
But I do have State of Minnesota in the Court of Appeals, case number A26-0006. It was dated, oh, it's so hard, January 12th, 2026. How Minnesota does their stamps and things, it's very different from here. And I forgot from my practicing days. Anyway, it goes on to give a number of statements based upon the file, the record, and the proceedings. And because there is a question whether this court has jurisdiction, in the end, the Court of Appeals states that his filing was untimely, and it says applicant's failure to file a jurisdiction memorandum may result in such sanctions as the court deems appropriate, including dismissal of the appeal. And then there is another order. It is not, again, they don't even write as clear as we do here. Another order that says, oh, wait, nope, that other order does, the first order said that he didn't do what he needed to do, and he wasn't in compliance. And then the second order said jurisdiction over this appeal is accepted. So it is in appeal right now.
Okay.
Anything you want to have him state after that, Mr. Anderson?
Well, I guess the only other question I would have then, if so they accepted the appeal, it sounds like. So then the question would be, Mr. Alciums, are you asking that the cabin in Burnett County be awarded to you on appeal?
Yes or no? It's a yes or no.
Yes, yes.
So,
Oh.
Your Honor, again, we're not taking a position on his request to get out of jail, but the concern, of course, on behalf of my client is that, well, he may not be able to have satisfy the purge condition now, but it's something that'll come up in the future if, it's a big if, but if the
Yep.
Court of Appeals or if he is awarded the cabin in the future.
Mr.
And again,
Anderson,
Your Honor-
I will point you to that findings of fact, and it is a very good read. I'm going to highlight some of the important things on the record now because it is very applicable to this situation. But Mr. Alciums wanted to say something first.
Yeah, just that, Your Honor, whether I end up with the property back in the future, and if I do end up renting it, as I stated on my letter, I will get the necessary permits from the county and the state if I'm ever in that position again. So,
Okay.
again, I've learned my lesson. I give my apologies to the court. It's kind of a flaw of mine, my personality. Kind of pig-headed and stubborn. So again, I just want to offer my apologies to the court. And again, if I do end up in the position of owning the property again and wanting to rent, with Scout's honor, I will follow your orders and get the necessary permits and And to the neighbors that are listening, I respectfully apologize. Again, in my mind, I didn't think I was being offensive with the rental activity. It was, everybody's been behaved. I don't think the police have ever been called. I have strict rules of people that rented. And I, believe it or not, I did think in the back of my mind of when I rented my property to respect the neighbors. So I don't think there's ever been any loud noise.
Well, we did go over all of those things and they were very detailed in the court's October 4th, 2024 order.
Right, well, I'm
And
saying.
then again in the August order, I believe. August 2025 order.
Yeah, so just, there's never been any loud parties and, you know, there's rules in a contract that says if there are, there's penalties for that. So I think it's been pretty respectful and, but again, I understand their feelings and I understand their desire to have that go through the county. So again, if I'm ever in that position, again, I will, you know, get the necessary permits from the county and the state.
All right, thank you, Mr. Osiums. And to kind of swing back, the loud parties, those things, that wasn't any main argument of any of the plaintiffs. It was the fact that you had 14 to 20 people that were staying at the property at the same time, that it took up not only your parking spaces in your property, but all along the side roads. And that is a very tight space. And that if you were to have complied and done what you needed to do, because you did rent over the 10 legal nights per ordinance, if you wanted to rent over the 10 nights, as you did, you needed to be compliant with state law and county ordinance and have your permits and your licenses, which you didn't. And if you did have those, that's where the county and the state come in and they say, you know what, this is the square footage of the house. This is the number of parking spaces. This is how many people you may rent to at a time. This is how many vehicles you may have. Because again, the off-site parking or not in your parking spaces is again, one thing that the county looks at with short-term rentals. So that's the main argument there. But I appreciate your apology to the court, Mr. Olsiums. And I do understand that your argument is it's a negative characteristic trait of your personality. When I look at the divorce document, there are certain things I want to highlight, and because again, it affects Burnett County, it affects credibility, it affects whether or not the court does trust that you're going to abide by the court's orders. Page 3, so some of the decree is numbered, but page 3, paragraph 11, it talks about discovery, and it says that you were served discovery in a formal discovery request on March 17th, 2025. And you were asked to provide certain proofs of income, earnings history, social securities, list of interest for bank investment accounts, retirement accounts, real estate values, those types of things. And it says that respondent neither responded to the formal discovery request, nor did he provide the requested information, and that is to the court. Petitioner through counsel has complied with all informal discovery requests from respondent because you served discovery upon your wife or ex-wife and she complied. You failed to comply. And here's where the court states that the court takes a negative inference against respondent for his failure to comply with discovery, including his failure to provide information to support his claim for spousal maintenance, non-marital claims, and asset valuation, because you didn't provide those things. And you did have a historic income that could be stated of, I believe, because you were a contractor, you did multiple different things, between $250,000 and $500,000. You had monthly expenses in the amount of $4,081 for all of your living expenses, every piece of your living expenses. That was your monthly living expense amount. And yet you requested spousal maintenance from your ex-wife in the amount of $4,000 a month. The court did deny that because based upon your work history, you are able to be self-supporting and you did not comply with any of the court's orders or the petitioner's formal request for discovery information. And so again, the court did take adverse inference against you for your failure to document your income, earning history, employment, and income capabilities. And they cited Minnesota case law that says that a negative inference does go against you for failing to comply with those legal requirements. It does go on and state that while you were married, you both were frugal, and that's a good thing. I am a frugal person as well, and I think that's how you can be able to save more of your hard-earned money. And you took frugal vacations that included reduced cost cruises, cheaper hotels where you're able to make your own meals without having expense to dine out. You lived in nice houses, but they were built to resell for income, and you kept the same furniture, again, commendable, but that your ex-wife could only shop at stores like stores of Walmart, TJ Maxx, Goodwill, and that she was only allowed to get 2 to 3 haircuts a month, but only at Great Clips. She could not get her nails done. She could not get her hair dyed or anything else like that. And she could not have or wear expensive jewelry. That you do have multiple properties, one worth 4.5 million, 2.8 million. And that on your homestead, the 2.8 million, that you only owe 365,000 and change for your mortgage, but that the mortgage was significantly reduced due to your ex-wife and her payments that she made when she was out of the home so that it would not go into foreclosure. That your Burnett County property has a high value of 741,000. And that it was awarded to Susan pursuant to the divorce decree that does not have any significant mortgage on it. However, the property is encumbered by 4 civil judgments. Burnett County Judgment 18FJ04 in the amount of $67,395 for Edina Realty. Burnett County Judgment 21SC179 in the amount of $25,119 for the Burton lawsuit, and Burnett County Judgment 23-CV-86 in the amount of $212,306, and that they were awarded your sole responsibility. And even though they are attached to the property, that you must solely pay that, and in some type of payment to your ex-wife that was to be due by February 7th, 2026. You have multiple other judgments in other counties in Minnesota as well as Wisconsin, and those are awarded solely to you for your responsibility. And that with the Burnett County property, again, it was awarded solely to your ex-wife, Susan, based upon the equalization of the property, which does include an equalization payment that she received this property plus some other things, but you still owed her that equalization payment of $1.55 million, again, to be satisfied by February 7th, 2026. And again, all of the other judgments are your responsibility in all other matters, shapes, and form. And then you did appeal, and the first one was denied, but then the second one, they did say that if you follow and you do all of the things that you need to do for the appeal, that your appeal will be accepted and it will be heard. But again, you have to do all the things that you need to do by whatever deadlines that they have. So that's the information on the record. As to why it's hard to judge your credibility, Mr. Olsiams, not only from all of the statements that were made in court and proved not correct, but in the fact that you were found in contempt many times. But at the last hearing on February 6, 2026, the court did ask you about the payment for the transcript that you did owe to the court reporter, and the fact that that was a lot of difficulty for the court reporter to get the transcript. You indicated on the record that you paid that amount by Venmo in the morning. However, then the court's order went out in the afternoon, but that wasn't correct. And the court said, it's easily verifiable. There's records of when payments were made and when orders went out. And you said, yes, I paid it by Venmo before the court issued an order. That's not correct. That was.
I said I made the payment today. I said I made the payment the same day as your order.
Yep. And I have, again, I can read it from this real-time transcript, what you said. You did say that, but then you also said, I paid it before the order was issued. You said that multiple times in this record. If you want me to go over and read to you what you said, I certainly can do that. But you said, I paid it before the court issued an order. That is not correct. In fact, that was a lie because the court issued an order. And then it wasn't until many hours later that you decided to violate the court's order and pay by Venmo when the court ordered strictly only payment by cash or check to the court reporter. And you paid by Venmo. Again, doing what you wanted to do and not what anyone else told you to do or ordered you to do. Again, with the whole credibility, this was brought up in another hearing. But the court did get the confirmation of it with regards to when I was looking for the findings of fact. The 10th District Judicial District criminal case in which you were convicted of multiple felonies and you were sentenced to 23 months in St. Cloud Prison, but it was stayed for 5 years. And that you must serve 45 days of that in the Washington County Jail, which you did. And the fact that you were convicted of, I believe it was 14 felony counts for swindling, tax evasion, or theft by swindle, tax evasion, and other multiple felonies. And so that goes against your credibility as well. So again, can you see why it's hard to believe your statements that you do not own the property and the court needed to find assurance that you did not own the property, but I do not have any documentation that it was yet transferred to Mrs. Olsium, or I don't know if she goes by Mrs. Olsium's anymore, but Suzanne. So I need to get confirmation that it was transferred to Suzanne's name only before I can see if you're unable to meet your purge requirements. And it's good to know that you are appealing and that is part of the appeal, even though I believe that the findings of fact is very thorough, very well written, and goes over all of the information necessary for the Court of Appeals to make a decision in the case. So based upon that information, the court is going to get confirmation that the document or that the property was transferred to Suzanne and her name only from the Register of Deeds for the title and the ownership. And after I do that, I can make the determination of whether or not you are even able to continue to meet the purge conditions, or if you are unable to meet them due to the reasons stated on the record. Is there anything else you would like me to know, Mr. Olsiums?
Just again, if I can just facilitate, I have a copy of that document. Again, I'm just requesting to be released as soon as possible.
I can't release you. I can't release you until I have that documentation. And so it's kind of a catch-22, isn't it?
That's why I'm asking, I don't know if you can give me special permission just to get that document off my phone. I'm sure the people would.
I can't, that's a jail policy. I can't give them an order to give you a phone because their policy is not to allow inmates to have it. But I do want to state on the record, Mr. Olsiums, I appreciate your statement and your confirmation that you do recognize that the sanctions order was necessary to stop the continuing contempt, and that you are going to abide by the court's order. if and when it is necessary. So I do appreciate that. So I will get the information I need, and I will get an order out as quickly as I get documentation, and then we will see if you're able to meet the purge or you're not.
I'm going to ask the captain here if he'd let me get my phone and take that document off. I can zing it up there as soon as possible.
Well,
And then
I'm gonna
try-
say again out loud here on the record that I don't need you to do that. I have the ability to get that document. So
Okay.
there's no need for the captain to give you special privileges to use your phone when no other inmate has the privilege to even touch their phone.
Okay.
So we'll go there. All right, now I'm significantly behind on my calendar, but I will get an order out and make my determination after I receive the document. Anything further before I adjourn?
No, Your Honor.
All right. Thank you. We are adjourned. Daryl Moose, the state appears through Assistant District Attorney Jose Vila in person. Mr. Moose doesn't appear. His counsel, James McLaughlin, appears in person. Off the record, the court was updated that Mr. Moose posted bail, although it's not yet sent to the court for the court's processing, but he was able to post. He is not on the jail roster. And so therefore we cannot proceed with a preliminary hearing. So Mr. Vila, what is the state requesting?
I would ask for a warrant, Your Honor.
Any further statement you'd like to make, Mr. McLaughlin, or stand mute?
I would only argue as his advocate, Your Honor, that Mr. Moose, there has not been official proof of receipt of the bond posted. So there theoretically, he might be in custody in a different jail, although highly unlikely. And I did let the court know that I attempted to make residential contact, but his local phone is inoperable. The only thing I could say on his behalf, if the court feels inclined to issue a warrant to give a stay for me to try to make arrangements for a voluntary appearance.
Unfortunately, I don't do that. So no stay would be granted. I have looked at the Burnett County jail roster, confirmed it myself. I have also looked at Vine. He is not in custody anywhere I can see. So he fails to appear. We just had his hearing not too long ago. So he had actual and oral notice of today's date and time, and he fails to appear. Therefore, the court will issue a warrant. And for the record, he does have a history of failing to appear. So the court will issue a warrant.
Is there a sum for which he can then add as an additional surety to obtain release, or would it be a body only? I'll let the court rule on that issue.
I rarely do body onlys because I
Okay.
want people to have the ability to be able to post if they can. Unless it's a serious case. This is serious, but it's not in the sense of the seriousness of other.
Community threat.
Correct. So the court will issue a warrant, an additional $250 to be posted. I'm not going to increase the $250. I do know that he has financial difficulties. However, I am forfeiting the cash previously posted pursuant to 969.13 of the Wisconsin statutes. I may set it aside upon verifiable information that it was not out of his control, or he was unable to appear by his own means for today's purposes.
The court read my mind. I'd ask if there is exigent circumstances that defense can later show. I'd ask the court to allow that possibility.
That is permitted.
Thank you, Your Honor.
Thank you. We are adjourned. Well, you didn't get to see that one, but you got to see another one.
You have such bright young public defenders coming over, Your Honor. They
do.
decided to send the old and competent one over, so you'd see the contrast.
Can I get permission to appear by his prelims by video?
Yes.
I mean,
Yeah.
this is probably the 5th or 6th time I've come over for prelims for him that he doesn't show up for on all this.
I am totally fine with that. I also go live.
Okay,
So you can just log into Court Live and you can watch it at that time.
okay,
Otherwise, I'm okay if you appear by video, but you have to make sure your name pops up press.
that's fine. I covered 10 counties, like I'm not in Burnett County. so
Yes,
I'm
I know.
driving.
Yes,
so,
I'm totally fine with that.
Okay.
But, and if you want the Zoom information, call my assistant. She'll be able to give that to you. But again, when you try to pop in, make sure it says press
Okay, perfect.
or whatever you are, the leader or whatever you are.
Perfect, thanks.
My opinion doesn't typically matter, but I have no objection to that, Your Honor.
Okay, thank you.
I wish you all good day.
Have a
Ms.
great day.
Capistrant.
Thank you, Your Honor.
Let me just see if this is Mr. Chavarria. Is this Mr. Chavarria? I just let into the courtroom. The Samsung, you're muted. I'm asking you to unmute and start your video. I don't know.
Can you hear me?
Yes, is this Mr. Chavarria?
Yes, ma'am. Yes, Judge Moore.
Okay, we'll get to you in just 1 second, okay?
Okay, thank you.
We will go on the record in the matter 26 CM 24, State of Wisconsin versus Cody Capistrant. The state appears through Assistant District Attorney Jose Vila in person. Ms. Capistrant appears in person with counsel Amber Sherwood. We're set here today in this matter for an initial appearance. At the last hearing, there was some discussion of giving information and having perhaps an amendment to an ordinance or something else. Ms. Sherwood, please update the court.
Yes, Your Honor, I spoke with ADA Vila this morning. I do believe that this matter is going to be dismissed in its entirety.
Excellent. So formal motion to dismiss,
So made, Your Honor.
granted. It is now dismissed.
Thank you.
So Ms. Capistrant, just make sure that you continue to talk with the Department of Health and Human Services and all of those things, and you're good to go, okay? Are you okay?
She's had a very hard couple of weeks, Your Honor.
I bet she has. Okay, Ms. Capistrant, if you want to wait just a little bit, Ms. Sherwood can be done in a second. I just have to go over another case with her, okay? So if you want to go have a seat in the back, or you can sit outside, whatever you prefer. We will go on the record in the matter 26 CF 07, State of Wisconsin versus Jose Chavarria. The state appears through Assistant District Attorney Jose Vila in person. Ms. Amber Sherwood appears in person, and Mr. Chavarria appears by video conferencing with late approval of the court, but apparently he was unable to get a ride. This is set for a preliminary hearing, but the court granted that due to the fact that Ms. Sherwood said that this would be a waiver of a preliminary hearing. Is that correct?
That is, Your Honor. I do have a waiver of preliminary hearing form. I was not able to get Mr. Chavarria to sign it as he was not here. I have read it to him. Would you like me to approach with this?
Yes. Did you read it verbatim?
I did read it verbatim, Your Honor.
Excellent. Thank you. Mr. Chavarria, I have in front of me the waiver of preliminary hearing form. It's not signed by you, but do you acknowledge that your attorney thoroughly read this to you word for word?
Yeah, yes, Judge Morgan. Yes.
And you understand everything on that document?
Yep.
And you understand the state has the burden to prove a felony was probably committed and probably committed by you?
Yeah.
And do you understand that by waiving your right to a preliminary hearing, you are agreeing that the state can meet that burden?
Yes.
You understand that once you give up your right to a preliminary hearing, it's forever and you cannot get it back?
Yes. Yeah, I understand that.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yep.
I will find that you are freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I find probable cause and I will bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I've gone through and filed the information. It mirrors the criminal complaint.
All right, proceed with an arraignment or set for another date.
We're asking for another date, so Attorney Reed may be present, Your Honor.
All right, then I'm not going that far out.
Cool.
March 6th at 9:30.
That would work for the defense, Your Honor.
All right, March 6th at 9:30, March 6th at 9:30. It's an arraignment. If Mr. Chavarria wishes to appear by video conferencing, he may. If not, he can be here in person, okay?
Thank you, Your Honor.
All right, thank you. We will see you then. We are adjourned.
Thank you, Your Honor.
Did you get those documents?
Yes, I went back and Mary pointed me straight to them.
Excellent. Thank